Okay, good evening, everyone. Good evening. The time is now 6:32, and it looks like we have a full house of participants. So the first thing I would like to do is thank you so very much for joining this very great conversation as it relates to financial legacy. We are looking forward to sharing information, and we have top tier presenters that will be providing you information that you can use today. So with that, I will introduce myself. My name is Selena Pickens. I am the founder and CEO of Money Management Solutions LLC here in Columbia. I am a proud member of Richland County Alumni Chapter of Delta Sigma Theta Sorority Incorporated. And I am super excited to be your moderator this evening. Again, we are going to have a good time. We're going to get some good information. We're going to learn how we can leave a legacy for our families, and we're going to get information on exactly how to do that this evening. But the first thing we're going to do is we're going to get things started out properly, and we are going to have our chaplain, Vereen, who is actually going to do the prayer for us. So if you all don't mind to just ready yourself accordingly, Jimmy Vereen, our NPHC chaplain, is going to give us a prayer.
Thank you. Let us look to the Lord in prayer. Father God, as we come to you this evening, we thank you for your many blessings. We thank you for your mercy, and we thank you for your grace. Father, we pray that you be with the speakers today, Father. Bless them, and may they be able to present their knowledge to us, Father. And also, Father, we pray that you also be with the NPHC at Columbia, Father. We had a wonderful session yesterday as we had all the Greek week activities going on. Bless this session that we're having today and continue to bless the D9 organizations, Father, as we serve your community, serve the Midlands community and the surrounding area. So continue to bless us and be with us. All this we ask in your Son, Jesus Christ's name we pray. Amen.
Thank you so much for that prayer. I really appreciate that. I needed that. We're going to move forward with our illustrious president, Dr. Andrea Fleming, who's going to bring us a formal welcome.
Thank you so much, Selena. And good evening, everybody. It is really awesome to see you all this evening. And again, we welcome you. I am Dr. Andrea Fleming. I'm a charter member of Iota Omicron Sigma Alumni Chapter of Sigma Gamma Rho Sorority Incorporated. And in this capacity, I am the NPHC president for the 2025-26 year. So we are excited to welcome you to our second event of our inaugural Greek week, which is chock full of a lot of amazing and very informative and fun events for the week. So we hope that you'll continue to join us throughout the week. Feel free to follow our social media as well as our website, which is nphccolumbiasc.org, if you would like any additional information regarding our activities and about the council as a whole. So just a tiny bit about the council. It is comprised of 16 graduate chapters here that serve the Columbia area of Alpha Phi Alpha, Alpha Kappa Alpha, Kappa Alpha Psi, Omega Psi Phi, Delta Sigma Theta, Phi Beta Sigma, Zeta Phi Beta, and Sigma Gamma Rho. And we're hoping to also welcome our Iota Phi Theta brothers as well. So again, we welcome you, and we look forward to a very informative evening with our special guest. So the agenda that we have in front of you is the introduction of speakers and the presentation that will be taken care of by our moderator. And then we will have a question and answer session, door prizes, announcements, and an evaluation that we really encourage you to complete so that we can get feedback about our activities for today. And we'll have closing remarks from our chapters. And we also really want to thank the chapters of Delta Sigma Theta and Omega Psi Phi for hosting this wonderful event. So you will hear from the leadership of those organizations. So we are very grateful for them taking the time to plan this event that we know, again, will give us a lot of takeaways. So our housekeeping for this evening, to make sure that we are handling things in an orderly fashion. Please keep your microphones on mute at all times unless requested. We ask that all questions and comments be placed in the chat for Q&A. It is being monitored. Be aware of your background if your camera is on, and this event is being monitored and recorded. So again, without further ado, I'm going to turn it back to Ms. Selena Pickens. Welcome.
Thank you, Madam President. We are going to jump right into the bios, and both presenters have given me permission to not read it verbatim. They have so much information that they want to share. We want to give you all every minute possible. So with that, I will start with Mrs. Tamika Isaac Devine. Tamika earned her Bachelor of Science degree from Hampton University, her Juris Doctorate degree from the University of South Carolina School of Law, and she began her law career as a staff attorney for the Carolina Regional Legal Services and later joined the South Carolina Attorney General's office. In 2001, she became the founder of Jabber and Isaac, and where she practices primarily in the areas of real estate, probate, and personal injury. In addition to the numerous legal political organizations Tamika serves on, she is a member of Delta Sigma Theta Sorority Incorporated, Jack and Jill of America, and she's on the board for the South Carolina Women in Leadership. Tamika is also, as we all know, a state senator, and she represents Senate District number 19, all right, which includes the northern and northeastern parts of Richland County. She was elected to fill as a special election in January 2004 to fill the seat of unexpired Senator for John L. Scott Jr. She had over 86% of the vote, and Tamika and her husband, Jamie, are the proud parents of Tamia, Jade, and Jameson, and their son, James Henry, was born into heaven in 2014. Now I will move to the next bio, which will be for Mr. Russell Brown. Russell O. Brown, Esquire, is a respected attorney and military veteran and a community leader. He's the principal attorney for Russell O. Brown Attorney at Law, LLC, and he has spent more than 2 decades helping individuals and families navigate important legal matters. He's a graduate of the University of South Carolina, and on his professional accomplishments, Mr. Brown is a dedicated community servant and mentor. Okay, he is a lifelong member of Omega Psi Phi Fraternity Incorporated, and he has held numerous leadership positions within the fraternity and currently serves as a corresponding secretary of the NPHC. With that, I'm sorry, let me make sure I add this. He is a husband, a father, an attorney, and an advocate for community empowerment. He remains committed to helping families build, protect, and preserve their legacies for future generations. So with that, I am going to allow the speakers to bring their presentations to give us all of this information. As a lifelong learner and a person that is very much into financial services, every time I hear a presentation, particularly done by either of these two, I'll get my pencils and pen out as well, because I want to take notes, because I learn something every single time. So I encourage you to get your pens, get your pencils, your iPads, your tablets to get ready to get this information. And as Dr. Fleming said earlier, we are going to have a question and answer session as soon as they get finished. So make sure you jot those questions down either on your pad or in the chat so that we can move it forward. With that, I will turn it over, I believe, to Tamika.
No, actually, we're going to start with Russell.
All right, we're going to start with Russell.
Okay, everyone. Again, my name is Russell Brown. I'm an attorney here in Columbia, South Carolina. I'm going to briefly go over wills, also healthcare power of attorneys, and other devices that you should use for yourself and your loved ones, your parents, if you have older parents or grandparents or aunts or uncles who are getting older. Some of the instruments that you can do or have executed for them. First, a will. What is a will? It's basically a written document stating how you want your possessions to be transferred to your heirs, your relatives, friends. They don't have to necessarily be a relative. Requires 2 signatures in South Carolina. You have to be competent. First and foremost, You have to be competent. The person that's making the will has to be aware of the date, time, place, location, and what they're doing. Okay? They have to be competent. Also, of course, they got to be 18 years of age or older. We'll have two witnesses. Typically, you want a disinterested person, someone who's not a relative by blood or by marriage. That way, during the will process, they're verifying that this person knew what he or she was doing, that they understood what they were doing, and they are witnessing that. And they will sign that document. That's very important. Those things, again, the person being competent and the witnesses have to be competent. It's everybody needs to know what's going on. And they don't have to be family members, but they have to be at least 18 years of age or older. You draft that will, you sign it and execute that will and have it notarized. And the notary can also serve as a witness. And the main thing is maintain your will. We always say the only good will in law is the original. Okay? Make sure you store it somewhere. A safe deposit box at a bank, buy a fireproof safe. Make sure whoever's in that will, they know how to get to the will. Because if you pass away and you're the only one with the key or the combination to the fireproof safe or the key to the safe deposit box at the bank, you got a will that no one can get to or execute and probate. Let someone know how to get to the will and all the important, again, the combination or the key. And so what that person is going to do, there's going to be in your will, you're going to nominate a personal representative. Again, that person has to be 18 years of age or older. And you should also have a backup, a secondary, because, that person may decline to serve as your personal representative, or they may pass away before you, or they may have some malady that prevents them later on from serving. They may, I hate to bring up an unfortunate incident, but they may get in a car accident, become a paraplegic, and they can no longer serve. So it's always best to have a primary and a secondary personal representative. And if you have children who are young, in your will, you can designate a guardian. The guardian takes care of the person, and the conservator takes care of that person's property. All right. And they can be one and the same. Again, those people have to be 18 years of age or older. But that's very important if you have young children to designate who you want to be the guardian and who you want to be the conservator. Again, they don't have to be the same person, or you can combine those roles. Once you've signed your will and had it notarized, again, safeguard it. And what will happen when you pass away, the personal representative is going to open up the estate at the probate court. Every county in South Carolina has a probate court. That judge is elected, and they have associate judges, but you'll file that will or record that will with the probate. Okay, there's a form, and you can download these forms to open up the estate. But that will transfers, it lets the court know and everyone know how you want your property handled. Let me go back to the personal representative. The personal representative doesn't have to be the oldest child. It doesn't have to be the baby. It can be a sibling, but whoever that person is, the primary and the secondary, you need to have someone who's going to handle business. If the oldest child doesn't really know how to handle business, it may not be best to nominate him or her as a personal representative. Get someone who's going to handle your business. A lot of times also, you may want to get somebody your age or younger, having your mom or your dad or even an aunt or uncle as a personal representative, there's a chance that they may expire before you because they're older. So typically get someone who's going to handle business and it's probably a little younger than you. Again, you go down to the probate court, open up the estate, and it's a process. But I will say the probate court in South Carolina, they really do work with you. They don't just leave you out there hanging, and it's a form process. Basically, complete a lot of forms. You're going to take care of your loved ones if they have any outstanding medical bills and such. You will help guide you will work the process to make sure that those hospitals or ambulance or whatever bills they have get paid. Now, that doesn't mean you got to pay it out of your pocket. A lot of people think, oh, I got to take care of my mom. I got to pay all these bills, pay it out of your pocket. No, you can pay it out of the estate. You have to liquidate some of the assets in the estate through the probate court to pay off these debts. But it's very important that everyone consider making a will for your spouse, your spouse, your children, whomever. That's very important. Also, we have a healthcare attorney, healthcare power of attorney, which is also important if you have older relatives and for yourselves. You never know, again, when some calamity may befall you, and that allows the doctors and your loved ones to know what you want to do if you're in a vegetative state. Do you want tube feeding? Do you want hydration? Do you want to be on life support? Do you want to donate your organs? These are things that you draft out, you write down, again, 2 witnesses who are competent. And you should also designate 2 individuals, a primary and a secondary, to handle that healthcare power of attorney affairs for you. Okay, that is very important. Now, with that document, remember a will. Let me go back to a will. There's really only one good will, and that's the original. The probate court doesn't store wills or no. If I got a copy of a will, I want the probate court to hold on to it, or I want the attorney to hold on to it. We typically don't do that. Well, our probate court doesn't do that because they have thousands and thousands of wills. And if you're a female and you get married, then you sign this will as in your maiden name, but now you're married, and now they got a will under your married name. And how do they correlate those documents? And so that's one reason the probate court does not hold on to wills or want copies of wills until a person dies. And the same thing with attorneys. At least for me, I don't make copies of wills, but then I got the same problem. I got to store this. Person may die 30 years later, and then I got to try to go through all these files for that will. So we give the individuals the will so they can maintain it. I'm going to switch back to the healthcare power of attorney for a second. With the now that document, you probably need to record. I recommend that you record it with the register of deeds. In some counties, they don't have a register of deeds or the clerk of court. The filing fee, I believe, is $25. You record your power of attorney. They'll give you a working copy, or you'll execute the document again to the disinterested witnesses, and have a notary execute the documents. Again, the person has to know what he or she is signing. And then once they've executed the documents, file it with the probate court or the clerk of court. So maybe a $25 filing fee. You'll get a working copy that you should give your mother or your father or your doctor, so he or she will know what to do if something happens to you. Okay, healthcare power of attorney. That's very important. Again, if you have older relatives, and it's hard to broach that subject because older people say, "Well, you plan on me dying?" We're all going to die, but sometimes it's harder with older people, and it's like a premonition that you're wishing them to be here no longer. But it's very important that you get these documents done. Also, with a regular or durable power of attorney that allows you to conduct the business affairs of your parents or your spouse. If they're not around, if you're in the military, I was in the military, your wife can execute and do everything you could do. Buy a car, buy a house, sell stocks, bonds, but it allows that person the opportunity to conduct your affairs if you're no longer able to do it. Okay? It's another very important document. You get one for your spouse, get one for you, your mother, every aunts, uncles, everyone. And again, these documents, again, with the regular power of attorney and the healthcare, file it with the clerk of court or the probate court. That way, you've got a record. The general public has a record. And if you lose your copy, you can always go down there and get a copy from the Register of Deeds or the clerk of court. Another it's not so much a document, but and I'm kind of getting ready to transition to Mika. With you, if your parents or you have a bank account, you can open up an account and you can put your children, your spouse, or whomever you want, and you can make them a payable on death beneficiary. Okay. They don't have access to the account, but when you pass away, okay, you would take a copy of the death certificate. Well, you won't do it because you're dead, but I say your family members will take a copy of that death certificate. They will go to that financial institution, and that institution will cut a check. Okay, because you have them as the payment on death, or sometimes it's known as transfer on death beneficiary. Most banks, it's like a one page or a 2-page form. You'll need the names, maybe the social security numbers and the date of birth. Okay, but that's very important. That helps you kind of avoid. You can't really avoid probate, but you can minimize your assets that your loved one who's deceased will when you fill out these forms that you'll report rather. But that's very important. And when you go to the bank or the financial institution, maybe I wouldn't talk to the teller, talk to the branch manager. All right. Just talk, hey, like I want a payment on death or transfer on death form. Again, 1 to 2-page form, name, social security number, date of birth, and they'll process it and hold on to it. And when you get your statements, some banks will actually put on their POD. They'll list your name and whoever the POD beneficiaries are. Again, they cannot access that money while you're alive. They would access those assets once you passed away. But that is a tool and device that a lot of us don't know about. But I also recommend that you do that. And again, if you have minor children, of course, there's some hurdles there, putting them as a beneficiary, but the money will still get there. We may have to get a guardian appointed or conservator appointed for those monies, but it takes you away from, it kind of gets you out of probate court with those monies. I don't want to eat up all the time. And I guess we can if there are any questions or how we want to handle questions, and then we'll turn it over to Tamika.
Thank you, Russell, for that information. We will have a question and answer session right after Tamika, once you all get finished with it. And we will answer the question, have you all answer the questions in the chat as well.
Thank you.
All righty. So good evening, y'all. Thank y'all so much for tuning in. Russell and I talked about this, and the biggest thing in our community is people do not properly plan. And if you do not properly plan, that is when people have issues. And so it is so important that you meet with an attorney and go through your estate planning. And so Russell talked about kind of the estate. What is your estate? Your estate is everything that you own when you pass away. And so, a lot of times I get people say, well, I don't need to plan. I don't need a will. I don't need, any estate planning documents because I don't have an estate. People think about an estate and they think like, the Ewings or the, the Rockefellers or, big estates. But everything that you own at the time of your passing is your estate. And it includes things like your real estate, your house, your car, the money that you have in bank accounts, even your personal items, your jewelry, and all that kind of stuff. And so you need to properly plan on what you want done if something were to happen to you. And so Russell talked about kind of our basic estate planning documents, your will, your healthcare power of attorney, and your durable power of attorney. And I tell everybody at minimum, everyone needs those 3 things. And really regardless of age, because I have had people, in their 20s pass away, and they may not own a house, but they own a car, they have money in bank accounts, and they haven't properly planned, and there's a whole deal. So it doesn't matter the age. But I'm going to talk a little bit about how do you, quote, avoid probate. And as Russell mentioned, avoidance of probate really shouldn't always be the goal. I 9 times out of 10, when people come in for my estate planning, and I ask them, I said, what are your goals? Or, why do you want to, do this? And they'll say, I want to avoid probate. all probate is, it is the process of transferring your assets when you pass away to whoever it's supposed to get to. So again, I said you need to properly plan. And if you don't properly plan, that's when people have issues. Most of the time when people tell me they want to avoid, quote, probate, they mean they want to avoid probate court. And when I ask them why, they tell me all these horrific stories. And the question I usually have is, did your, mom's estate lasted 3 years and people were fighting, etc. And I ask, did mom have a will? And usually the answer is no. So if you properly plan, if you have your estate planning documents, then most of the time you will not have that headache in probate court, because all the probate court's job is to oversee the transfer of your assets so that they are done properly. And if they are not done properly, then that's when you have issues. I did want to say one thing to follow up on some of the things that Russell talked about. He talked to you about the probate process and going to probate court and doing that. Just so you all know, also a big issue in our community is people think, oh, okay, well, mom passed away and then dad is still living, and then dad passes away and, cousins living in the house, and they don't think anything about it, and they don't probate the estates. In South Carolina, you have to probate an estate within 10 years of somebody's passing. If you do not do that, then the process itself is a lot more complicated. It's going to cost you a lot more money, and it may not actually give you what you need. And so, if someone has passed away and you're thinking, oh, I don't have to, it's quote heirs property. Y'all, there's no such thing as heirs property. There needs to be a transfer from the decedent to the heirs in order for it to become heirs property. So we need to make sure that you do probate an estate. But with all that said, I get a lot of people who will come to me, and when we talk about, well, they say their goal is, they say, I want to trust. And I want, the question I ask is, well, why do you want to trust? And 9 times out of 10, their answer is, I want to avoid probate. So I always tell people that, a trust is certainly something to look at. And I'll talk a little bit about trust in a few minutes. But there are also, if your goal is to avoid probate, or at least minimize, like Russell said, the things and the assets that have to go through the probate process. Again, it is about proper planning. There is a way that you can do that without actually doing a trust. So let me share. I'm gonna share my screen again. Go to share. Alrighty. All right. My techie is not wanting to work with me. So I want to talk to you about a few ways to avoid the probate process. And so first of all, you need to understand, what is your estate? What do you own? And when you are thinking about what you own, that is the way that we can kind of figure out how do you set things up so that you don't have to go through the probate process. Okay, so here we go. Share. Okay. So starting with this, these are a few ways that you can avoid probate. And Russell talked about the first one. If you have money in a bank account, and so that your money does not have to go through the probate process, you need to look at how you have that account set up. And so if it's husband and wife, and I get lots of husband and wives, and she's like, I got my money, he's got his money, we don't have joint accounts. That's fine if you don't want joint accounts. But if there's no reason for you not to have a joint account, you really need to go ahead and have a joint account. Because if you have a joint account, then that money automatically passes to the joint account holder at passing, at your passing. And it doesn't have to just be husband and wife. It can be, you can put your children on it. I'm on all my mom's accounts. And so, although I'm a joint owner, I'm not stupid. I ain't going to go in her money right now. So I know people will say, okay, I don't want a joint account because I don't want people to have access to my money. Okay, that's fine if you don't. But if you have a joint account, just know that they can actually legitimately go into the bank now and do anything on the account if you add them as a joint account holder. So don't add somebody you don't trust, but you can add somebody as a joint account holder. But if you don't want to add somebody as a joint account holder, exactly what Russell said, you can make them a payable on death beneficiary, and banks will call them POD accounts. So when you go into the bank, say, hey, I want to make my account POD. And all you're doing is you're adding the name of who you'd like that account to be payable to upon your passing. And so if you have a POD account, then that money goes directly to that person upon your passing.
Something,
Now,
excuse me,
mhm.
Tamika, something happened
Yeah.
and you blocked out for a
Oops.
little bit. So you might have to go back to right when you said we can go to the bank and do the POD.
Okay. All right. So if you do a POD account, it doesn't give them access to the account right now, but what it does is it makes them the payable on death beneficiary. So upon your passing, that money will automatically be payable to them. All they have to do is go into the bank, show your death certificate, and the bank will allow them to have the money that was in that account. And so that way, that money will not have to go into probate. The really interesting, a really good part about that is, of course, upon your passing, there are things that need to happen. You know, your mortgage might still have to be paid. There's funeral expenses. There's other things where there is a need to have immediate access to an account. If your money has to go through a probate process, it may be, 3 weeks to a month before a personal representative is appointed to get access to that money. So really think about having a POD account. The second way to avoid probate certainly can be to create a trust, and I'm going to about that in a second. But creating a trust is a trust is its own separate entity, and you can create a trust, and then you can put assets into the trust. And I'm going to talk about that in a second. The other thing is looking at how you have deeds to your real property. How is your property titled? If you have your house, if your house is not owned with you and your spouse as joint tenants with right to survivorship, then guess what? Your spouse's half of that house, once they pass, has to go through probate, even though you own it with them. So that's my homework to you all. If you own your house, especially if you've owned your house like over 20 years or so, because now real estate attorneys, we routinely will do husband and wife as joint tenants with right to survivorship. But years ago, a lot of times they didn't do that. So you want to make sure that you do own your property with joint tenants of right to survivorship. Let me put this down. But you can also do what's called a life estate deed. And that means if you are older, you're going to live in the house for the rest of your life, you can retain a life estate, own the house upon your life, and then upon passing, it can transfer to your heirs or whoever you want to get it. As far as automobiles, any vehicles that you have, if you have a title and you and your spouse or you and somebody are on title, please make sure it is titled as or. If it is titled as or, it automatically passes to that person upon your passing. If it's titled as and I know it sounds like it should be the opposite, but it's not. So if it's titled as and, that means that automobile would have to go through the probate process. So please make sure that you check your title if your spouse is on it. If you're not married or you don't have your spouse on your vehicle, you can also do what's called a transfer on death provision with the on your vehicle. There's a form at the DMV, and you can go fill it out. You can add who you would like to be your transfer on death beneficiary for your vehicle. And then upon your passing, same as the POD account, all they have to do is go to the DMV, file your death certificate, and the car becomes theirs. And that avoids probate. And then also make sure you have life insurance policies. Make sure that you have a beneficiary on your life insurance policies, but also make sure that you have a backup beneficiary. Y'all, I cannot tell y'all how many times I've had people will have a beneficiary on a life insurance policy. That person predeceases them. They don't have a backup. And then guess what? Once you pass away, your life insurance policy becomes payable to your estate and not to anybody, which that means that money would go through the probate process. So these are a few ways that you can avoid probate. And when you sit down with an attorney, they're going to go over your assets. They're going to go over how you can minimize the things that are going to have to go through probate. So the big question, people always ask, a trust. People come in, I want a trust. And so just simply what a trust establishes a legal entity to hold and manage the assets for the benefit of a beneficiary. And so you don't have to have a lot of money for a trust, but honestly, to be honest, if your only goal is to avoid probate, a trust might not be financially um, the wisest choice. To set up a trust, it's a significant investment, and you can do estate planning significantly less than setting up a trust. But having a trust requires two steps: creating the trust, and that's what an attorney will do. They'll create a trust. It usually takes a couple of weeks. It's a significant document. It's probably 80 to 100 pages if it's done and done correctly. And then you have to fund the trust, meaning you have to then put assets into the trust. So if you spend money setting up a trust, then you have to actually transfer assets into the trust. So if you have a house, you then have to title the house into the trust. So if you have a mortgage company, if you have a mortgage on your house, you need to talk with your mortgage company before you set up a trust and put something in a trust, because they may not let you put your house in a trust if you still have a mortgage. If you're going to put bank accounts in a trust, you're going to have to retitle your bank accounts, etc. So just know that there are two different steps to that. Some of the pros and cons of a trust. Of course, the benefits are, like I mentioned, it avoids probate court, the privacy. Anything that goes through probate court is a public, is public. So anybody, if they're nosy enough, they can go and look up your probate file and find out what your assets are at the time you passed away, if things have to go through probate court. So some people like a trust because of the privacy of it. Two, you can control the distribution. So if you have minor children, you don't want 15-year-olds inheriting a house and money. So you can structure the distribution in a trust, and so that's why some people like it. There are some possible tax benefits. I'm not a tax attorney, so I always tell my clients, talk to your tax preparer or your financial planner to find out if there are benefits for you. And then, of course, the possible protection from creditors. And I'll talk about the difference between the types of trusts to see whether or not it will protect you from creditors. And then it survives incapacity or death. So if you are fine now, but then you get dementia, you've placed your items in the trust, your trustee can handle things and not have to worry about getting a conservatorship or something through the court. Some of the drawbacks are the cost. It is a significant cost. I mean, it's going to be thousands of dollars to set up a trust. And so sometimes that seems to be cost prohibitive for some people. The complexity, you have to get into a lot of detail, because again, the trust survives incapacity and death. And so you need to plan well out. And so it can be a complex document. If you have an irrevocable trust, then you lose some control over your assets. And so that's sometimes a drawback. Administration, there is ongoing administration for a trust, and of course, no oversight unless you go to court. So I have a case right now in which a beneficiary is suing the trustee, and they had to actually bring a lawsuit because there is nobody that is overseeing a trust, like as opposed to probate court. You've got a probate judge, like Russell talked about, that oversees it. This is small. Y'all are going to get the slides, so I'm not going to go over all this, but there are two types of trust. There's a revocable trust and an irrevocable trust. Basically, a revocable trust, it can be changed, it can be amended, it can be revoked by you during your lifetime. You maintain control over it, so that's one thing that most of my trusts are revocable. Your assets remain part of your grantor's of your taxable estate. But it does not provide significant asset protection. I get a lot of people think just because you have a trust, it's going to protect you from creditors. Most of the time, it's only going to protect creditors, and definitely it only protects Medicaid if it's irrevocable. And I'll talk about that in a second. The grantor can serve as a trustee, so again, you keep that control. And then the income from in the trust is reported on your personal tax return. So it's really kind of like pass forward. It's just really like you're still owning the process, and it's easier and less expensive to create, as opposed to irrevocable trust. Generally, it cannot be changed or revoked once it's created. So if you're going to create an irrevocable trust, you need to do it and recognize that you lose a lot of ability to do things to it. You give up control of your assets that are transferred to the trust. And so that's why the irrevocable trust is what protects you against Medicaid liens and things like that. So if somebody's doing estate planning and asset protection for Medicaid purposes, most people will ask, what if I get older and I have to do Medicaid? That usually a irrevocable trust is what you want to look at. But I'm be honest, in our community, especially if you want to be able to borrow money against your real estate, or you want to make some changes, irrevocable trust is very limiting, and so it's not always the best avenue. So my simple rule of thumb is understanding irrevocable trust, you keep control and you can avoid probate. Irrevocable trust, there is protection, and there's tax or Medicaid planning. So there's a lot of planning to go into it. And so most of my clients who are looking just to avoid probate and they still do want to do a trust, like they have minor children, or they want to structure their distributions, we do a revocable trust for them because they maintain control of their assets and they can have that flexibility. Usually, if my client is looking at ways to protect their assets, particularly for Medicaid, then we're doing an irrevocable trust. But like I said, there's severe limitations on that. Deeds, I just wanted to touch briefly on deeds. I mentioned before, I want you all to look at the way you hold title to your property because most of the time, our biggest asset is our real estate. And if your real estate has to go through probate, it can tie up your home for a year. And it a lot of times that is probably the biggest thing that people have issues with. So if you want to make sure that your house does not have to go through probate, then you want to look at the way you have it titled. And you can do things like I mentioned, a joint tenant with right to survivorship or life estate deed. And then that means that you won't have to worry about it transferring through probate court process. I do want to point out one thing though. Debts of an owner can attach to real estate. So if you're going to put your children on your house, just recognize, if you got a son that's got like some child support issues or some debts, you may not want to add them on your deed because their debts actually can attach to your real estate, and that's one thing that sometimes people don't realize. And I'm right on time. I think, Selena, that is all the assets, and that's all the things I had about a trust. But regardless of whether or not you want to do a will, the temporary estates planning, or a trust, the biggest thing is number one, knowing what your assets are. Number two, knowing what your goals are, and then being honest with the attorney that you're going to sit down with so that they can help you properly plan. A trust may or may not be best for you, but at minimum, you definitely need to have the will and the powers of attorney.
That was excellent, excellent, excellent information. Thank you to both of you for providing that information. We know it was fast, but you know what? The thing about what you said was that this is recorded and we're going to have it actually on the YouTube page so they can go back and look at this because it is a lot of information. And I know they're clapping for all of everything that you all said and the fact that it's going to be on YouTube. So in any event, this is great information. And Tamika, I'll just say that last part that you said about making sure that you attach the right people or not people who may have some outstanding debts, because a lot of times people really don't know that. And you don't want to have an extra situation for your family or for you while you're still living if something actually happens and you attach someone with significant debt onto your mortgage. So please be very careful. Thank you for sharing that and all that you have shared. So what we're going to do now, we have a lot of questions. I saw them popping up in the chat. So I am going to turn it over so that we can get those questions answered to Stacy Gatson. He is going to be our facilitator for the questions. So get ready.
Thank you so much for that. So either Senator Devine or Brother Brown, does the power of attorney ever expire?
Well, a power of attorney expires on the death of the principal. Okay. So if you have a power, if a person has a power of attorney for the mom expires. Yes. All right. That's when that's when you open up the estate and you become the personal representative or the executor. So yes, it does have the lifespan of the principal.
Thank you, sir, for answering that.
And Stacey, can I add on that? The other thing
Absolutely.
people, and Russell mentioned this, that your power of attorney is recorded in the county in which the principal lives. Just know that if you decide you want to change who your power of attorney is, you actually have to revoke the power of attorney, and that also has to be recorded. So you can't just do another, say, I appointed my sister, but now I don't want my sister, I want my brother. You can't just then execute a new power of attorney and appoint the brother. You have to revoke the first one.
Thank you. We appreciate that. The next question said, can you execute a POD for vehicles? And Senator Devine, I know you talked about the transfer of death as well as the when you're looking at the title, it needs to have or, but is there anything else that needed to be added for the question, can you execute a POD for vehicles?
Yeah, no, it's basically TOD. So it's the same thing. It's a transfer on death. And that is a form act, and that just actually that form was just approved by the General Assembly 2 years ago and went into effect July 1st of 2025. So it is a new document. You can go online, just put in transfer on death, SCDMV transfer on death, and the form will come up, and you can go ahead and fill out the form online and just take it to the DMV if you want. But it is a new document, so if you weren't aware of it before, it's new, but it is a transfer on death, and you can even put as many beneficiaries as you want.
Awesome. Thank you. And then next question says, does that form at the bank allow the check to be cut without the money being held by probate?
Yes, that's the whole purpose. So if you have three kids, or however many kids, if you have $30,000 and you have your children down, uh, all as the payment on death or transfer on death beneficiaries, all three, they'll cut a check to all three.
Awesome. All
And,
right.
and, and some banks will say, hey, look, there's 30,000, everybody's getting 10. Some banks will say you can set up, you can set up your percentage. Well, the older two, maybe they get 20 and the baby gets 10. Just you got to talk to your bank or your financial institution if you're with a credit union.
Absolutely. And then are either of you all able to speak on the importance of having a POA and healthcare POA for your children who are over the age of 18 and you are divorced, so the parents are not fighting over who makes the decisions?
Yeah, no, I can speak to that. And honestly, it doesn't even matter about the marital status. If your child is 18, and so I've got a 20-year-old in college, and before she left for college, I had a POD done for her. I mean, a power of attorney done for her because just know once they're 18, legally, someone cannot discuss stuff with you, even though you're their parent. So it is important that you do have powers of attorney, healthcare, and durable for your children so that somebody is able to take care of it. But yes, certainly if you have a situation where, you might have parents that don't have great communication, you want to make sure that you have that done because if child gets sick and you're at the hospital, it might cause confusion.
Thank you for that. All right. So the next question talks about, can you add someone as a joint account holder without them knowing?
Well, you're going to need their social, all right, at a minimum. But I don't know what the purpose of that would be because if you die and they don't know, they got money that's coming to them, they won't act on it. So transparency and communication with friends and family is best.
Yeah.
They need to
And if
know.
Yeah, and if you're adding them actually, and again, it's two different things. If you're adding them as a joint account holder, they do have to know because the bank is going to require them to come and sign. Just like you sign a signature card, they're going to require them to sign. So they need to know if they're a joint holder. Now, if the question really is if you add them as a POD, do they have to know? I don't think the bank will require that they know, but as Russell said, if you add them POD and they don't know about it, then that money's going to sit there and they don't know to go there. So you need to make sure that you are giving them that information.
Absolutely. What about, are you able to add more than one name to a POD?
Yes.
Yep.
Yes.
And I guess this is going to be a question for the NPHC. Can we get a list of persons and contact information to create a trust? Or actually for both of you all as well, are we able to get a list of persons and contact information of where to create trusts?
Sure. And I think the PowerPoint that y'all will get has both Russell and I's information. I think Russell said you don't want to do trust right now. I am doing them right now. They are complicated, and so I am doing them right now. If I don't have the capacity, I can refer you to somebody else. But yeah, we have lots of local attorneys, lots of African American attorneys who are doing trust. Well, I said lots. There's probably about 5 of us that do it. So if you'll have my contact information, reach out, and if I don't have the capacity to do it, then I will refer you to another very good attorney.
Awesome. So if someone has a name change, do they need to change the name on the will, the POA, and beneficiary?
Yes.
Okay.
Yes. Yes.
Thank you for that. All
And
right.
can
What
I
is the
add, that's another question. Also, not just a name change, you should update your estate documents upon any major life-changing event. So if you get married, if you get divorced, if you have a child, if you become a widow, you need to update your documents. I mentioned before about the beneficiaries. I cannot tell you how many people come to me and then we look at the will and the who they named as personal representative has died, and so then it defaults to the intestate statute, or beneficiary has died. Or I've had people that the beneficiary of the life insurance policy is ex-wife and the new wife is pissed off and I can understand that, but it's because you didn't update your documents. So please make sure that under any major life-changing event, need to make sure you are updating. And if you have a change of something, name or otherwise, you need to update it.
Excellent information. What is the best way to transfer real estate under a mortgage to avoid probate after death?
So again, you can do a trust, but you would need to ask the mortgage company for permission. Mortgage companies are more and more are allowing that, but that's not the only thing. So if you are going to do like a life estate deed or a joint tenants or right to survivorship deed, mortgage companies will let you do that all day, every day. And so that is the best. That is the best thing is adding somebody to the deed, and then you retain ownership. Now you need to retain some type of ownership. So you need to stay on it. You can't just transfer it. Like I have people who say, okay, I'm going to transfer this to my son because I'm moving to, Still Hopes or whatever. You can't do that. You can't take your name off and transfer it to somebody. That's a violation of your mortgage, and that will accelerate your mortgage if your mortgage company finds out about it. But if you're just adding a beneficiary so it'll avoid probate, your mortgage company will allow you to do that.
And
Okay.
I'd like to add another point. If when you pay off your mortgage, there's a piece of paper, 1 to 2 pages, called a satisfaction. When you get that satisfaction, file it with the register of deeds or probate. Well, the register of deeds or clerk of court. Now, some mortgage companies will file it for you. Some will just mail it to your house and open up your junk. It looks like junk mail, and get that doc. It's a very important document because that's telling the public and everybody else you have paid off this mortgage. The mortgage is satisfied, and you record that. Because if you don't, the public doesn't know that. So if somebody's doing title searches and lien searches and all that, you still got a mortgage out there. Now the bank knows you paid it, but no one else knows, and your family members won't know. Record it. It's maybe what, $25. It's again 1 to 2 pages, but that's very important. That's your
Thank
proof.
you.
That's recorded proof that you have paid that mortgage.
Excellent information. All right, so the information that has been shared, does it apply when a person is a court-appointed conservator and guardian? And can a conservator and guardian put assets in a trust on behalf of an incapacitated family member?
So great question. So a conservatorship actually trumps a power of attorney. So someone could have appointed power of attorney, and then when you go in for a guardian and conservatorship, if it's the same person that the POA is, a lot of times the probate court will then ratify the power of attorney, but it could be somebody different. It could be, one child had the power of attorney, but that child isn't doing what they want to do, supposed to do, so the other child files for conservatorship, and the probate court appoints them. So then that overrides the power of attorney. About putting assets into the trust, you can do. You have to ask court permission. So the conservatorship is put in place, but there are limitations to what a conservator can do. And so the probate court will oversee the conservatorship and guardianship. You have to do annual reports to the probate court about financial reports as well as how the incapacitated adult is doing physically. And so if you want to transfer assets into a trust or do whatever, you need to ask permission from the court. And once you get that court order, yes, it would allow you to do that.
And another
Awesome.
thing, if you have along those lines, if you have an adult child that's maybe has autism or some sort of malady, again, like Senator Devine said, you're going to have to record every year. You're going to have to update those records because they want to make sure that one, that you as a conservator and guardian are still alive, and that individual is still alive. So they'll mail it to you. The probate court here is very helpful. They'll mail you a form. You complete it. You'll take a picture of that incapacitated person, and you'll file that with the clerk of court.
Thank you. If you do not file the POA or healthcare POA is not recorded in the county, does it make it invalid?
No, it doesn't make it invalid, but the recording process adds a little bit more legitimacy to it. Okay, and it puts it out there on the record, the public record. But it doesn't minimize that fact. But I do it for my clients. We're going to go down here and we're going to record this. So I think the extra $25, just record it. Ounce of prevention is worth a pound of cure.
Absolutely. All right, so next question says, if you have a trust but need to update it, do you have to take it to the same attorney or can you go to a different attorney?
You can go to a different attorney. You will need to have the original trust because the original trust will talk about amendments and changes to the trust. And so you would need that attorney to review it. So it may be actually more cost effective for the old attorney to do it because they drafted it. So they may not have to spend as much time reviewing it, but it just depends. Like I have clients who've moved here from, another place. And so the attorney that would need to amend it is in another state and their state laws might be different. And so we do it, but it doesn't have to be, but sometimes it makes more sense to have the old attorney do it.
Awesome. How do you add an adult child beneficiary to your deed?
How do you,
A quick claim deed. So if you're going to, and it says beneficiary. So the state of South Carolina, we have legislation that has been introduced to have a transfer on death deed in our state. Our state don't do transfer on death deeds. We have the life estate and the joint tenants right to survivorship. Hopefully we will get a transfer on death deed. And so if we do that, then that person will be a beneficiary. But right now we don't have that. So the only ways that you would add your child now would be, like I said, the remainder interest in a life estate or as a joint tenant, and you just do that through a quick claim deed. But it makes them, if it's a life estate, they become the beneficiary. If it is a joint tenant, they become an owner now. So just understand you are placing them on your property now.
Absolutely. All right, so if you own joint property with your parents and you are now married, can you place that house in a trust that is owned by you and your husband with the consent of your parents?
Um, yes, if I understand the question, if you and your parents are on the property and now all agree, then yes, y'all would do a quick claim deed on that property into the trust. So yes, it's not even just consent. Physically, all of you will have to sign the deed because you're all on title to put the property into the trust.
Okay. If you got your will done via on base, can you get it updated or changed by a civilian attorney?
yes. Yes.
Awesome. Awesome, awesome, awesome. All right. So, Senator Devine and Brother Brown, it looks like that was the last question that we have. So I am thank you all for answering those questions, and I'm going to turn it back over to the moderator.
Well, thank you very much. Did an excellent job with those questions, and so did the audience. That just lets us know how much this information was needed with those questions. And with that, I think we just need to give them a hand. If everybody can just use those emojis and give them a hand, you all did an excellent job. Again, like I said from the beginning, I always learn something new, and I did very much so. So thank you all again for that. Next, what we're going to do, oh, we have a lot of hand claps coming in. Keep them coming. Can you all see that? It did an excellent job. Yes. Okay, with that, what we are going to do is we are going to do a, we're actually let the presidents give a closeout from each of the presidents from all four chapters that we have. We're going to start with Dr. Prince, and then we will move to Stacey Gatson. And I'm sorry, we will start with Dr. Prince, move to Lavelle Thornton, then go to President Stacey Gatson, and then Tremaine Matthews. And after that, don't hang up because what's going to happen is we're going to have a wheel and somebody is going, people who have registered who are on the call, we are going to have a wheel and someone is going to win a prize. So don't hang up because you must be present to win. It won't take that much longer. So looks like we are really, really good on time. So we want someone to win. So stay on the call. So with that, Dr. Prince, are you ready?
I am ready. Thank you so very much. Good evening to everyone. I am Arlene Prince, chapter president for the Columbia SC Alumni Chapter of Delta Sigma Theta Sorority Incorporated. We want to thank you so very much for joining us for such an important and informative session this evening on Wills and Trust. Tonight's session reminded us that preparing for the future is one of the greatest gifts we can offer our families. We extend our heartfelt appreciation to our dynamic presenters, attorneys Tamika Devine and attorney Russell Brown, for sharing such informative information and equipping us with the tools that we can use in the future to protect our families and generations to come. And we would also like to express our gratitude to the Divine Nine Partners in Service, the National Pan-Hellenic Council, who plays an instrumental role in spearheading the events that are taking place during our inaugural Greek week, which started on yesterday and will end on Sunday. So our special thanks to our NPHC president, Dr. Andrea Fleming, and also to our facilitator, Ms. Selena Pickens. We want to thank you so very much for all that you have done today. And also we want to thank our members of our NPHC who had a part in the program this evening, our NPHC chaplain, Mr. Jimmy Vereen, and and you haven't, I guess, met her yet or heard from her yet, but our NPHC technology chair, Ms. Janaea Lee. We want to thank them for all that they have done. And to each of you who have joined us this evening, we say thank you. And there was a lot of good information as you heard, and we want you to know that knowledge is powerful. So after you leave today, I encourage you to take the next steps, have the conversations, complete the documents, and put plans in place that honor your wishes and protect your loved ones. Because there was a lot of good information that you can utilize for the future. At this time, I say thank you so very much, and I wish you a good night, and I will turn everything over to Miss Lavelle Thornton.
My name is Lavelle Thornton, and I serve as president of Richland County Alumni Chapter of Delta Sigma Theta Sorority Incorporated. And I echo President Prince's remarks. These are trying times, trying financial times. And so it is so important that we make the most of our money, make smart money moves, and get our house in order. Hopefully these tips have provided you food for thought and information that you can use to secure your financial legacy and protect your loved ones. My grandmama used to say, when you know better, you do better. So I truly did take notes, and I'm going to record these and share them with my family, because I'm willing to bet you that many members in our family members, many members in my family do not have their house in order. And you know the division and the chaos that can cause when people die unexpectedly, things happen, and you need money, and it's all this drama. So I really appreciate the information that has been given. It was a lot of detailed information to digest. So I'm grateful that the slides will be available. The information is recorded, and our guests can use this information at another time. One thing that stood out for me is the importance of having an experienced professional, a lawyer that specializes in some of these kinds of things, because it sounds like things are changing all the time. So the importance of competent counsel, I think, is another key take-home message that I will definitely use and share with others. And with that, we're just so glad that you thought it not robbery to join us this afternoon. We wish you a great week, and I will now turn it over to President Gadsden.
Thank you, Ms. Thornton. So my name is Stacy Gadsden. I am the president of the Omicron Phi chapter of Omega Psi Phi Fraternity Incorporated. We are celebrating 100 years this upcoming November. So we will have some events that will be taking place, and we hope that the community will be able to come out and help us celebrate 100 years of service to the Columbia area. With that being said, I just wanted to thank the NPHC for their vision on starting this NPHC week here in Columbia. It is an awesome feat, and so far things have been going real well. And I expect nothing else, for the rest of this week as well. Another huge shout out to Senator Devine as well as to Brother Brown as well. You all did an amazing job, and thank you so much for being willing participants tonight. And thank you all. You know, the wills and trust information was definitely needed. And Ms. Thornton, I'm going to go ahead and say, you know, thank you for kind of stealing my thunder as well. But it remains, it's something that needs to be said twice, which is when you know better, you do better. And, you know, we as African Americans definitely to make sure that we are doing better when we know better. So I yield and to my cohort, my counterpart, I should say, from Chi Iota Iota, which is Mr. Tremaine or Brother Tremaine Matthews.
Thank you, Brother Gasson, and good evening to everyone. I echo a lot of what was just mentioned. I want to thank all the presenters, all the work that went on behind the scenes to get this NPHC week going. Unfortunately, this is the first event that I had a chance to attend, but I teach classes in the evening. Look forward to trying to get out a little bit more throughout the week. We just have our Secret Garden event coming up, scholarship event. If you could purchase tickets and attend that, that would be great. But if not, appreciate all the support that we do receive. Thank you, Senator Devine. Thank you, Attorney Brown. Thank you, Dr. Fleming. And again, like I said, to all our moderators and participants. Thank you.